What are the 7 steps of the California probate process? When someone dies, the money and property which makes up their estate will be distributed to their heirs. Usually, for those assets to be properly distributed, the estate must go through a probate. This involves several steps, including proving the existence of a valid will if applicable, identifying and inventorying the property, appraising the property, paying debts and taxes, and then distributing the remaining property. Before the proceedings can get underway, the court needs to appoint someone to oversee the process. If there is a will, it typically appoints a personal representative to take on this duty. If not, the court will appoint someone to serve in that role. Here are the 7 basic steps required in the California probate process. Step 1. Filing the petition. The first step in starting a probate is filing a petition with the California Superior Court in the county where the loved one resided at the time of their death. This petition will trigger the court to schedule a court hearing. Step 2. Handling of notice. After the petition is filed with the court, the notice of hearing will be published in the local newspaper. It is also required to mail the notice to everyone named in the will if there was one, along with all legal heirs of the deceased. Notice must also be provided to potential creditors. Step 3. Proving the will. If there is a will, it is necessary to prove the will unless it qualifies as a self-proving will. In some cases, the will contains specific language which makes it unnecessary to prove the validity of the will. Step 4. Asset collection. One of the primary duties of the personal representative is to take possession of all probate assets. There are some types of estate planning instruments that are not required to go through probate. If the title of an asset needs to be transferred to someone else, the personal representative must take care of that. Some types of assets that may require a title change include stocks and bonds, mutual funds, brokerage accounts, banks and credit unions, physical assets such as real property, motor vehicles, boats, and planes. The court requires an inventory of all property. Sometimes, an appraisal of certain property may be required. Step 5. Payments to creditors. Once the personal representative has provided notice of death to creditors, those with debts owed must submit a claim. If those claims are determined to be valid, they will be paid from the estate. All valid debts must be paid before other distributions can be made. California requires creditors to submit their claims within 4 months of the appointment of the personal representative. Step 6. Estate tax payments. The personal representative is also responsible for making sure all estate taxes are paid. That includes federal and state taxes, which the state of California imposes. If the estate has been distributed before the taxes are paid, and there isn't sufficient property left to pay those taxes, personal liability may be imposed. Step 7. Conclusion of the estate. The final step is closing the estate. This final step involves providing an accounting of all actions taken by the personal representative. The petition also includes the fees to be paid to the personal representative and the estate attorney, if applicable. If there are no objections and the court approves the accounting, then an order will be entered by the court concluding the estate. Once this happens, the personal representative can then distribute the remaining assets to those receiving the estate and pay any necessary fees. If you have questions regarding probate, please contact Schomer Law Group using the contact information in the description below. Please don't forget to subscribe to our channel and catch all of our future videos.